You're watching the Lawyers Committee for Better Housing live call-in show. My name's Lacey Burpee. I'm a staff attorney with Lawyers Committee for Better Housing, and this is Samira Nazem, also a staff attorney with Lawyers Committee for Better Housing. We're here to talk a little bit about Lawyers Committee today, also called LCBH, and let you know what we do and take in any questions that you have about any general eviction issues. Let's see. So Samir, do you want to tell us a little bit about the history of LCBH?
Sure. So LCBH has been around for over 30 years. It originally started as a small organization up in Rogers Park with just a few attorneys who were trying to preserve affordable housing and protect tenants' rights up in that neighborhood. So since then, we've grown quite a bit. We now have 8 full-time attorneys and a staff of over 20 people, and we work throughout Chicago and the rest of the state, advocating on behalf of tenants. Throughout all this growth, our fundamental belief has remained the same, and that is that all people have a right to safe, decent, and affordable housing on a non-discriminatory basis. And we further that goal through a combination of direct legal services, individual and public advocacy, supportive services, and community outreach. We have several different program areas that we house in the Lawyers Committee for Better Housing, and each of these sort of has a different focus in terms of protecting renters. Our first project is our Eviction Defense Project, which is a high-volume eviction defense practice. We are in the Daily Center, in the eviction courtrooms, basically every day, representing tenants who are facing eviction for a variety of reasons, be it non-payment of rent, retaliation, discrimination, foreclosure, or anything else. We handle over 300 cases a year, trying to keep individuals and families in their homes as best we can. Our second program area is our Affordable Housing Preservation Project, which works with large buildings to try and preserve the quantity and quality of affordable housing throughout the city of Chicago. Through that program, we're able to go in and work directly with groups of tenants and tenants' unions to advocate for maintenance throughout the building, for property managers to better preserve buildings, and to try and halt the destruction of affordable housing throughout the city. We also run a program dedicated just to working with tenants who are impacted by foreclosure. So many people think the foreclosure only impacts homeowners, but here in Chicago, there are actually more renters who are displaced by foreclosure every year. These are innocent tenants who just happen to have the misfortune of living in an apartment building where their landlord has fallen behind on mortgage payments and has lost possession of the building. So we have a program that's devoted to representing those tenants in court and to providing counseling and information services to them through our hotlines and our help desk at the Daily Center. And lastly, we run a tenant advocacy project, which works with tenants who are in disputes with their landlords that haven't yet escalated to litigation. So it may be a situation where a tenant wants repairs made in their apartment and the landlord won't make them, or maybe a tenant needs help with a lease negotiation or any other one of a variety of situations that may come up. Through that program area, we are able to help tenants advocate on behalf of themselves and negotiate with their landlords to see if we can resolve their problems without having to go into the courtroom.
All right. Thanks, Samira. And I just want to remind everybody that you can call in with your questions. The number is at the bottom of the screen at 312-738-1060. And do you want to just talk a little bit about some general information about the courts and eviction?
Sure. So the eviction process here in Illinois is a multi-step process. I think there's a lot of confusion sometimes about how to properly evict a tenant. And that's on the part of both landlords and tenants. But we have a lot of protections in place here that clearly state what steps a landlord needs to follow before he or she can evict a tenant. There are a lot of evictions that are filed every year in Chicago. In 1996, which is when LCBH did a court monitoring project last, we found that there were over 40,000 evictions filed. So with that many evictions, every year. You can imagine those cases move quite quickly in the courthouse. In those evictions, we found that about 90% of the time the tenants are pro se, so that means they don't have an attorney who's stepping up in court with them. When a tenant has to go to court without an attorney, they are far more likely to be evicted than a tenant who does have legal representation. About 95% of the time in eviction court, a tenant without an attorney will be evicted. But if they do have an attorney with them, that number drops to about 50%. So as you can see, having an attorney makes a difference. It makes a really big difference because this is a multi-step, complicated process, and there's a lot of misinformation about what rights and responsibilities landlords and tenants have when it comes to eviction. So I'm going to talk for a minute here about what the eviction process should look like here in Illinois if it's done correctly.
And we have a slide for that, so I'll put that up
Thank
so
you,
everyone
Lacey.
can see it.
So to evict a tenant in Illinois, a landlord needs to follow many steps. This is probably a little hard to see on TV screen, so I will walk you through what these steps are. The first thing that a landlord needs to do is to give written notice to the tenant about why they want to evict them from the property. They need to let them know why they're seeking to terminate their tenancy, and they need to put that in writing. And they need to give that to them before they can file a case or take any further steps to evict a tenant. There are different kinds of notices that a landlord might give depending on why he or she is seeking to evict that tenant. It could be that the tenant hasn't paid rent. It could be that the tenant has violated some other provision of the lease. Maybe the tenant had a dog and the lease prohibits pets or something like that. Or it could be that the tenancy has just ended. The lease has run out and the landlord doesn't want the tenant to stay there for another year or another month, however long the lease term is. Whatever it is, that landlord needs to give the tenant notice about why he or she wants that tenant to leave the apartment and end the tenancy. After that notice has been given, the landlord needs to wait for a certain number of days, and that again will depend somewhat on what kind of notice it is. The most common kind that we see is non-payment of rent, which in those situations the tenant would have the right to a 5-day notice, and the landlord would need to wait 5 days before filing an eviction case against the tenant. So once that notice period is run, the landlord can then go downtown to the Daily Center and file an eviction case in the courthouse, trying to bring the tenant into court. Once that case is filed, the next step is the landlord needs to get proper service on the tenant. So that means that the sheriff or special process server would need to go and give a copy of the court papers to the tenant. In some situations, tenants can be served by publication, which means that they would have a copy of the summons mailed to them rather than personally delivered. But that is usually seen as a last resort, not a first resort. So the landlord would need to try to get direct personal service on the tenant first. After the tenant has been served with court papers, then both parties will go back to court and there will be a trial. Court can, without attorneys involved, is usually a very quick process, just a matter of minutes. At some point during that court appearance, the judge will make a decision about who has the right to the apartment, the landlord or the tenant. And if the judge rules in favor of the landlord, the judge will then enter what's called an order for possession. Now that's lawyer talk for an eviction. The order for possession is the court paper that legally evicts a tenant at that point. And then there's actually one more step that isn't on that slide. But once the order for possession is entered, then the landlord will need to place that with the sheriff. And the sheriff of Cook County is the individual who will actually come out and enforce the eviction. Just having an order for possession doesn't give a landlord the right to go home and change the locks himself.
Great, and it looks like we have our first caller, so we can put them on the air. Hello?
Hello?
Welcome to CAN TV. What's your question?
Hi, I just received a notice from my landlord on Wednesday saying that I have to be out within 5 days. And I'm curious exactly what that means. I wasn't able to pay my rent on the 1st, but I should have it the full amount by tomorrow. And I told my landlord about being late a few weeks ago, and he didn't seem to have a problem with it. But I haven't been able to get a hold of him since Wednesday, so I'm not sure what to do. And also, I'm curious, does the 5 days mean next Wednesday, or does it do the weekends not count, or is it Monday? I'm confused and a little concerned.
Okay, well, thanks for calling. Those are some really good questions, and this is definitely a little bit confusing at times. So we're going to do our best to help you understand what's going on here. So as we just mentioned a minute ago, a 5-day notice is what a landlord gives a tenant when he believes that that tenant hasn't paid rent or has fallen behind on rent. And a 5-day notice, there are a lot of requirements about what kind of information it should include. But under the state law, it should give the tenant an opportunity to cure. So what that means is if the tenant can come up with the money and pay within those 5 days, then that should stop the eviction. Now, you asked if the weekends are going to count. Do you need to pay within 5 business days or 5 calendar days? The answer is calendar days, unfortunately. So even if there are a few weekend days in there, you're still going to need to pay on the 5th day after when the notice was served to you. If you do have the money and you're able to pay within the 5 days, I have a few pieces of advice. First of all, you need to pay the entire amount that your landlord asks for in the 5-day notice. Paying a portion of that amount is not necessarily good enough to stop the eviction. So you should be careful about making sure you pay exactly what your landlord is asking for. And when you go to pay, you should bring a witness and you should get a receipt. Sometimes in court, a landlord may deny receiving certain payments. So as much proof as you have is always helpful. So if you can pay with a check or a money order or something where you can track that the payment was made, or have a witness who can testify that you made the payment, anything like that was very helpful in court. And if you do pay within the 5 days, that should stop the eviction from going forward. If your landlord does proceed with the eviction anyway, you should certainly go to court and show them whatever proof you have that a payment was made, and that would be a defense to the eviction.
And that's something that our organization might be able to help with. I'll put up those numbers in a moment. I think just one other thing, the 5-day notice does not mean that you have to get out within the 5 days. In order for you to be evicted or be forced to leave, the landlord does need to take you to court. He can't take matters into his own hands and lock you out of the apartment after those 5 days.
Absolutely. That's a really important point that Lacey made. We showed that slide earlier. There are many steps that need to happen before a tenant can be evicted. So a 5-day notice doesn't mean you have to be out in 5 days. It just means that you have 5 days to try and come current on your rent before your landlord will start the eviction proceeding.
So I'm going to put up our numbers really quick for if you need help. If you are being evicted, you can call 312-784-3527 to speak with our office to see if it's something that we may be able to help you with, and to see if you qualify for our services and get more information about how we may be able to help you. And it looks like we have another caller.
Hi.
Hi, what's your question?
Hi. I am living in, I think, a foreclosed building.
Mm-hmm. And why do you think that it's in foreclosure? Oh. And I think we lost her. Maybe she'll call back.
Well, although this is a good opportunity to talk a little bit about some of the special protections that are available to tenants who are in foreclosed buildings and what you can do if you think your building might be in foreclosure. First of all, if you have reason to think your building may be in foreclosure, you can contact LCBH. We have a hotline, one for the city of Chicago and one for the rest of the state, where we have staff and attorneys who can help you do a foreclosure counseling to determine what's happening with your building. And Lacey's putting those numbers up right now.
We have the city number. Oh, I'm sorry to interrupt. We do have the city number up. It's 312-784-3507.
And if you go through foreclosure counseling and find that your building is in foreclosure, there are certain protections that you might have in that situation. Although it looks like we have another caller, so we'll get back to that question in a minute.
All right. Hi, you're on the air. What's your question?
Yes, I was curious, in the scenario that you just said, can you hear me?
Yes.
Okay. I was curious with the situation that you just set up in terms of the tenant paying all the back rent due within those 5 days. I was curious if a tenant actually did do that, and then after those 5 days, or within the 25 more days left in the month, if the landlord tries to still evict them, like saying, I want you out by next month, after they have gotten the current month's rent, is there any type of remedies that the tenant may have?
Well, if the landlord decides to go forward with the eviction, even after the tenant has come current on their rent, the tenant would have a defense to the eviction. So the tenant should certainly go to court if the landlord proceeds with the court process, and alert the court that he or she came current with the rent within the 5 days. And again, you will probably need to show proof there. So rent receipts, a cash check, a witness, something like that to confirm you made that payment. And that should be enough to have the eviction case dismissed. Now, I'm not sure if you're asking if there are additional remedies available to you in terms of trying to sue a landlord or something like that. That's not really something that our office handles in terms of those affirmative lawsuits, but it could possibly be something that you might want to talk about another attorney with.
And I just want to note one more thing. We have another caller, but really quickly on that same note, sometimes you can be current on your rent and still be evicted for some of the other notices that Samira had mentioned earlier, the 30-day notice, or if you break your lease. So, sometimes you can cure the notice, and sometimes their notice is just, if it's the end of your lease, that just end without you being able to cure it.
Right.
Even if you are paid up on rent. All right, next caller.
Hello?
Hi, you're
Hello.
on the air. What's your question?
I don't know where to start, actually. I'm in a building. I've been here for a while, several years, but, the hot water is sort of iffy. Last winter, the heat didn't work all the time. We're worried about that again this year. There's roaches now. And I'm worried that, if I speak up or do anything wrong, the landlord's going to want to kick us out. And, even though there's problems, I got my mom, I've got my kids. It's not a good time to just be moving right now. And some other tenants are organizing, and I don't really know, if that's allowed or what to do, actually. So...
Great. Well, thank you for calling. Those are some really great questions that you raised right here. And unfortunately, this is a situation that we see quite often at Lawyers Committee for Better Housing. So it sounds like you have a question about what to do with this tenant union, and then another question about some of the problems, the conditions in your apartment. So hopefully we can do our best to address both of those. First, you mentioned that some of the tenants are organizing in your building, and you want to know what to do, whether you can get involved or not. So here in Chicago, we have a ordinance that actually protects tenants who decide to form and join tenants unions in their buildings. It's called the Residential Landlord Tenant Ordinance, and it has a provision that protects tenants for 1 year when they do things like exercise rights or join tenants unions. It protects them from retaliatory evictions. So that means if a landlord tries to evict you for joining a tenant union, you would be able to go to court and you'd be able to argue that it was retaliatory, and that could be a defense to your eviction. However, it doesn't mean that your landlord can't evict you for cause if you do something else like not paying rent or breaking your lease. One very important thing to know about the RLTO is that it doesn't apply to everyone in Chicago. It only applies to buildings that are over 6 units or are not landlord occupied. So it doesn't apply to small buildings if your landlord lives in it. So for example, if you're in a 2-flat and your landlord's upstairs, you would not be covered under the RLTO. And if you are in a situation where your building's starting to form a tenants union, there are many organizations you might want to speak with also. Our organization works with large buildings and tenants unions, so you could certainly call Lawyers Committee for Better Housing at the numbers on your screen to see if there are any services we could provide. And there are other organizations like Metropolitan Tenants Organization that work with tenants in buildings. Now, you also mentioned that there are some problems with your apartment, that your landlord hasn't made repairs, and there are some conditions that you're not happy with. The RLTO, the same statute that protects tenants from retaliation, also provides some remedies for tenants who are in a situation like that where the landlord just won't fix the problems with the apartment. There are a few different options that are available to you as a tenant if you are in a building that's covered by the RLTO. The first thing that you would need to do to take advantage of any of those remedies is to send a letter to your landlord formally demanding repairs be made. That kind of letter is called a 14-day letter because you need to give your landlord 14 days to make those repairs. And if you need help writing a letter like that, you can contact our organization. We do work with that through our tenant advocacy project. In your letter, you should formally request repairs be made and let the landlord know that if they are not made within 14 days, you will exercise one of your rights under the RLTO, and that can include either withholding a portion of your rent or breaking a lease if the situation is particularly severe, or making the repairs yourself and deducting the cost from your rent. All of these are things that you should consult with an attorney before actually taking advantage of, because there are some requirements that need to be met for them to properly be done under the RLTO. So if you're in a situation like that, please call our organization for more information.
We have one more call. Do we have time to take it? Let's try and take this one
Let's
quickly.
take this one quickly.
Hi, what's your question? Hello?
Hello?
Hi, what's your question?
Hi, my mother-in-law recently had a stroke, and I was going to install like a bar in her bathtub to help her get in and out. And her landlord said I can't put any holes in the wall. Is there anything I can do to push back on that?
Thanks for calling. That's a great question. And in a situation like that, there are remedies that are available to your mother-in-law. Because what she's doing is requesting something that's called a reasonable accommodation. So that means she's asking her landlord to make a special exception for her because she has suffered some sort of disability that has injured, in this case, her mobility, and she needs a little bit of extra help. In this situation, you can write a reasonable accommodation letter to your landlord requesting that he or she make this reasonable accommodation for your mother-in-law. And unless this is something that the landlord thinks is unreasonable for some reason or another, this is something that he should allow you to do. Now, one thing that you need to know is that this will be at your cost. So if you would like to make these repairs and you get permission from your landlord, you will need to pay to install the bar yourself. And the landlord can ask you to uninstall it when you leave the apartment and to restore the apartment to the condition it was in when you first moved in. If you're requesting something that is reasonable, your landlord cannot deny you that request under federal law. There are protections for tenants who have disabilities and need some special accommodations to be made. And again, that's exactly what our organization does. So you should certainly call Lawyers Committee for Better Housing and see if we can help you with that situation.
Great. So I think we're almost out of time, but quickly we will go over the upcoming episodes. Let me just put those up. So next week we're going to be having another general discussion about renters' rights. The week after that we're going to be talking about the Keep Chicago Renting Ordinance, which is also called the Protecting Tenants in Foreclosed Properties Ordinance, which is the new city law that offers more protections to tenants who are living in foreclosed buildings. And on October 25th, we have a special guest from the Center for Conflict Resolution coming to talk to us about landlord-tenant negotiations and mediation. So
we hope you'll be able to join us for some of these upcoming episodes, and we're hoping to bring on more special guests over the next few months.
So yeah, thank you for joining us.